Now, there's a lot of laws, page 13. I sure don't know them all. I field a lot of these questions from clients. I go to employment lawyers. Once a month, I'm going to an employment lawyer saying, hey, my client has this situation. Do I need you? Which special laws apply? So you probably, if you have 6 or more employees, you probably should know who a good employment lawyer is in your community. If there's only one good one, hire them so that they're conflicted out from representing your employees later, if you're in a small town. And just get to know them. Page 14, keep good records, and don't lose the copy of the employment agreement that they signed. Employees are famous for stealing their agreements on the way out and wiping the scan off your computer. And then you can't even prove that they did it. So you have to be careful. Non-competes on page 16. And then page 17, this is really helping on one of our situations I have going right now, where a physician has hired a very good employment lawyer to sue my group for harassment, for alleged harassment, but that has to go to arbitration because we had her, when she was hired, sign an arbitration agreement. So she's going to have to pay that $10,000 arbitration fee and have 3 arbitrators who are all labor lawyers. She's not going to be able to go to a jury. Now, finally, please write them up. You can do it very constructively. You can say, hey, Matilda, you've done a great job this week, but I have to ask you, what can we do so that you don't forget to make the copy of this that needs to go into that file? You got to please do that. Don't just talk to Matilda, just send a friendly email. At least it's documented. Then the second time, do the employee noncompliance thing. Say, our law firm requires us to fill this out. You've done it 3 times. We can't have you in that position anymore. We're going to have to find somebody else. So, and then when you terminate them, you can't terminate them for any of the reasons on page 22 or for any of the reasons on page 23. And also, you should not discuss anything about these things in the initial interview, or if you're the supervisor of that person, these things are off the table for you to discuss. So you have to be very careful. You don't want to be accused of firing somebody or not hiring somebody because of page 22 or 23. And when they lead you in the interview into these areas, you change the topic back out of these areas because they may be just trying to set you up. You do have to be careful. Now, when you terminate someone, you don't have to tell them why you're terminating them. You could just say, we decided it wasn't the best fit. We wish you the best. You're going to do really good somewhere else. We'll help you any way we can, but please leave. Yes.
Can we use Facebook comments as a determination for hiring?
Not officially. That was a good question. Can you use Facebook comments as a reason for not hiring somebody? And I would say, have other reasons, but don't hire them. All right. Finally, you can use an investigator, and we often have. An investigator can make a great impression. When an employee gets out of line and starts making phone calls and stuff like that, an ex-employee, there's nothing wrong with a private investigator knocking on the door saying, you've been saying bad things about this company. I'm investigating the situation. Can you tell me who you've said this to and why you're saying it so that we can try to straighten this thing out? And that may be the last time they ever make a phone call about your company.